Thank you, Mr. Chairman. The ranking member offers us an example of an upstanding, law-abiding Marylander in the case of Brego Garcia. As Mr. Ice has said, Mr. Garcia has been identified as a member of MS-13, the most violent criminal gang on the planet. And there's one report just published that he's implicated in human trafficking in this country. Not exactly Rotary Club material, I think. But shouldn't the circumstances of his case be examined in an individual action before a district court and not dumped into a far-reaching edict arising from another case that has very different circumstances? Mr. Larkin, what's your opinion of that? Your microphone.
How about now? My mistake, sorry. My understanding is these actions that have been challenged under the Administrative Procedure Act, not as actions seeking federal habeas corpus relief. Mm-hmm. Federal habeas corpus is the traditional remedy that someone uses when they're claiming the government has unjustly seized them. There's even a provision for next friends.
And that option exists in law, and I think that that's the appropriate option, is it not?
The Administrative Procedure Act is not.
Yes.
For example, you can't use Section 1983 to challenge the legitimacy of your conviction. You have to use the Habeas Corpus Act. Right. So,
well, and again, these are individual cases with very different individual circumstances, and ought to be.
That's right. I mean, what you have, a particular John Doe, number 1, 2, 3, whatever. Each case has to be examined separately, but it should be in habeas corpus, not the Administrative Procedure Act.
Mr. Gingrich, I'm told that 92% of the judges who've issued blanket injunctions against the administration have been appointed by Democrats. That at least suggests a rather partisan tilt to all this, and it's not being done even-handedly. What's your view of that? Doesn't that undermine public confidence in our courts?
Well, I think if you look at the recent reports from various polling firms, clearly a majority of Americans believe that no single district judge should be allowed to issue a nationwide injunction. And I think that when you look, in my judgment as a historian, this is clearly a judicial coup d'etat. You don't have this many different judges issuing this many different nationwide injunctions, all of them coming from the same political ideological background, and just assume it's all random efforts of justice. This is a clear effort to stop the scale of change that President Trump represents. And I agree, a lot of this stuff can be fought out, some of it should be fought out in the Congress, but it shouldn't be micromanaging the executive branch on national security issues by random single judges who have no standing, they have no particular knowledge, they haven't been in the room, they don't know what the consequences of what they're doing are, and they put both Americans and the nation at risk when they intervene to become basically alternative presidents. You now have potentially 677 alternative presidents, none of whom won an election.
Well, we all believe in due process. Every injured party should have access to the courts, and they do. The question is whether a single district court can go beyond the case before them and apply the same decision to others whose cases are not before the court in jurisdictions that go far beyond their own. Mr. Gingrich, you've pointed out that there are several ways to address this. One is congressional action. The other is the Supreme Court putting its own house in order. In fact, the Alito dissent recently suggests that there are at least 4 of the justices who very much want to do this. It seems to me that's the cleanest and most surgical route, assuring that the rule is done from within the court and not imposed by legislation. What are your views on what the Supreme Court should do and on what you already mentioned what we should do?
Look, I think the Chief Justice would achieve far more for judicial independence if he cleaned up his own judiciary rather than lecturing the rest of us. And I think there are ways he could intervene, as I mentioned in my testimony. They could establish a rule that any nationwide injunction issued by a district court will be held in abeyance and will be immediately appealed to the Supreme Court. Lincoln makes this case. Very head-on fight, which is ironic because Chief Justice Taney, as Attorney General for Jackson, had ruled against the courts. And it said, as Attorney General, the courts cannot order the president. Now, he then becomes Chief Justice, extends slavery potentially to the whole country. and is lectured by Lincoln in his first inaugural as Tawney sits there. And Lincoln is essentially saying, this was the law of the case, not the land, and we will not enforce it. And they don't. They never enforce Dred Scott. And so I think Chief Justice should think seriously about intervening to preempt any requirement for something such as Chairman Ice's bill, which I support strongly, but would be no reason to have it if the Chief Justice did his job.
Thank you.